Welcome to The Explainer. Today, we are looking at a complete, ground-up overhaul of Sri Lanka's anti-corruption landscape. We're talking about a legislative earthquake that has completely rewritten the rulebook on how bribery and corruption are investigated, prosecuted, and punished. It's the Anti-Corruption Act number 9 of 2023. And honestly, it's a massive piece of legislation that you absolutely need to understand, whether you're a government official, a corporate executive, or just an everyday citizen.
Now, I want you to just think about this question for a second. Does corruption only happen in government? For decades, the prevailing assumption, and frankly the legal reality in a lot of places, was that anti-corruption laws were strictly designed to police public officials. If you worked in the private sector, you probably thought these laws didn't really apply to your day-to-day operations. Well, as we're about to see, that assumption isn't just outdated. Holding on to it right now could literally land you in very serious legal trouble.
Okay, let's dive into this. Here is our roadmap for how we'll unpack this today. 1. A new anti-corruption era. 2. The private sector shift. 3. Meet the watchdog, CIABOC. 4. Sweeping investigative powers. And 5. Whistleblowers and penalties.
Part 1. A new anti-corruption era, rewriting the rules. So, Sri Lanka's old Bribery Act? It's been completely repealed and replaced by the new Anti-Corruption Act. And a primary object of this act, stated right there in its opening pages, is to give effect to Sri Lanka's obligations under the United Nations Convention Against Corruption. This is not just a minor local update, guys. This is Sri Lanka elevating its laws to meet internationally recognized norms and best practices to establish a true culture of integrity. Moving on to Part 2, the private sector shift. You are now liable.
Now, what's really interesting about this contrast is the massive shift in focus. Under the old Bribery Act, the focus was strictly on the public sector, specifically private citizens or businesses giving bribes to public officials. But under the new act, the law applies to both the giving and the taking of bribes within private sector entities. Every single employee and director of a qualifying private entity is now prohibited from soliciting or accepting an advantage to breach their duties. The game has totally changed, and private employees are squarely in the crosshairs.
You might be wondering, what exactly counts as a private sector entity under this law? The Act refers to entities specified in the Sri Lanka Accounting and Auditing Standards Act. In plain English, we're talking about licensed banks, insurance companies, leasing and finance companies, stock exchanges, and listed companies. If you operate in the financial or public markets, you are definitely covered. But crucially, it also includes qualifying unlisted companies. Let's actually break down what makes an unlisted company qualify, because this net is cast incredibly wide. Your unlisted company is subject to this law if it meets just one of these thresholds from the previous financial year: a turnover of more than 500 million rupees, shareholders' equity over 100 million rupees, gross assets over 300 million rupees, liabilities to banks exceeding 100 million rupees, or simply having a staff of over 1,000 persons. If you hit literally any of these numbers, this law applies to you and your employees, period.
Section 3. Meet the watchdog, CIABOC, the Independent Commission.
This isn't just your average government department. It's a highly independent, specially structured body. The commission consists of 3 members appointed by the president. And the qualifications? Incredibly rigorous. One member must have at least 20 years of experience in law, and the other 2 need 20-plus years of expertise in fields like forensic auditing, crime investigation, or public administration. Plus, to ensure absolute independence, they have to relinquish all other remunerated offices before taking the job, and they only get a single 3 to 5 year term, which guarantees fresh, uncompromised oversight.
But the commission members don't work alone. They are supported by a director general. And to hold that role, you need a minimum of 15 years of experience in criminal prosecutions. Yep, 15 years. This proves that the operational head of this watchdog is a highly specialized, deeply experienced criminal prosecutor. This isn't some bureaucratic figurehead. This is a serious law enforcement professional. This director general basically acts as the CEO and the chief accounting officer of the commission. But most importantly, on the direction of the commission, this is the exact person who will actually institute criminal proceedings. They are the ones signing the indictments and the charge sheets. All right, Part 4, Sweeping Investigative Powers, the Commission's Arsenal. First up, and this really demonstrates the sheer intensity of this enforcement, warrantless arrests.
Authorized officers of the Commission can arrest a suspect without a magistrate's order and completely without a warrant. If an officer has reasonable suspicion or credible info that an offense under this act is happening, they can literally physically take you into custody on the spot.
Next is total financial paralysis. If the Commission suspects your assets are tied to bribery, they can issue a written order to any bank or financial institution to instantly freeze your accounts and stop you from disposing of property for up to 3 months. And get this, they can do this before they even go to the High Court within 7 days to seek confirmation. Your assets can be locked down almost instantly.
They can also ground you. The Commission has the explicit power to direct immigration and emigration, or any police officer, to impound your passport. If they suspect you're involved in an investigation, they can legally stop you from leaving Sri Lanka for up to 3 months.
Now this is where it gets straight out of a spy movie, with an ex parte warrant from a high court judge, which means a hearing where you aren't even present. Investigators can legally engage in covert surveillance. They can bug devices, intercept your emails, listen to your telephone and internet calls, and record video or voice conversations. Your digital wall of privacy can absolutely be breached for an anti-corruption investigation.
And if you think your encrypted apps are going to save you, think again. The law specifically empowers the Commission to apply to a magistrate to compel service providers to unlock or unencrypt devices and services. They have the legal backing to force the handover of your digital data.
And this brilliantly illustrates the massive upgrade we are talking about here. While they obviously still have traditional powers like summoning witnesses, seizing documents, and taking fingerprints, they now have these special investigation techniques codified right into the law. We're talking undercover operations, controlled deliveries, and even legally authorizing an informant to give or receive a bribe just to trap a corrupt official. They've totally modernized their toolkit to catch highly sophisticated crimes.
Section 5. Whistleblowers and penalties. The stakes have never been higher.
If you are an employee who sees corruption and actually reports it, this act builds an absolute fortress around you. First, any provision in your employment contract trying to discourage you from reporting is legally void. Second, you're protected from adverse conditions of employment. And third, and this is a huge one for HR departments, this includes harassment by your coworkers. The law states that coworker harassment against an informant is treated as being committed by the employer itself, even if the employer didn't know about it. So it is incredibly dangerous for a company to try and silence an employee. And what happens if you're caught violating this act? 7 years. A violation carries a penalty of imprisonment for up to 7 years, along with fines that can reach up to 1 million rupees. The stakes have literally never been higher. So the crucial point is captured perfectly in this analysis by Heritage Partners. This law is a notable paradigm shift in that it applies to both the giving and taking of bribes by private sector entities. We've moved from a world where only government officials had to look over their shoulders to a reality where corporate executives, bank managers, and private directors are under the exact same microscopic scrutiny. Which leaves us with this final, critical question to wrap up our explainer today. Is your company's compliance program actually ready for this new era? With whistleblowers fully protected, sweeping surveillance powers authorized, and severe jail time on the table, ignorance of this new Anti-Corruption Act is just no longer an excuse. It's really time to review your internal policies. Thank you so much for joining me on The Explainer, and I'll see you next time as we keep decoding the data that drives our world.